Get started. Please ask the officials to join us. We have formed a quorum of 4. Good afternoon, members. You know, last time there were some questions for which we sought answers from the administration. There are 2 remaining parts concerning G and H. Arising from the 2 June meetings, the administration has attempted some answers. Whether you are satisfied or not is for you to judge. But let's take a look. And before he took leave, Mr. Vincent FANG wrote in, raising some points concerning imported refuse, and whether the refuse would have been dumped in our landfills. And he also requested the administration to give answers. And that letter was sent in just before Mr. FANG took leave. So we have referred the letter to the administration. So, Mr. Albert Lam, would you like to give a verbal response to Mr. FANG's letter? And then after that, if members agree, maybe we can proceed to cross by cross. Today we have Mr. Albert Lam, Deputy Director of Environmental Protection, Mr. Samson Lai, Assistant Director of Environmental Protection, Ms. Selina Lau, Senior Government Counsel, and Ms. Libera Chang, Senior Administrative Officer. All right. Last time we discussed some policy issues, and you have provided us with a paper covering points to G&H, and you may also wish to cover the letter from Mr. FANG. We have just received Mr. FANG's letter. He raised 2 points about the tricolored recycling bins and the problems arising from the lack of a proper outlet for the collected plastic waste, and the point that such waste would end up in our landfill. And also there's another point about imported plastic waste. We have already responded to point number 1. As for the second point, I believe the panel would convene a special meeting to discuss the matter. Maybe we should defer to that panel meeting. Yes. Mr. FANG has raised those points arising from the PSB levy. This is a matter of concern to Mr. FANG, to me, and to other members. Well, there will be a special panel meeting, and I believe at that meeting we will be talking about the recycling bins. So if members agreed, I think we better leave the matter to that special meeting for a more thorough discussion. Yes, the EA panel has arranged a special meeting at 10 a.m. on the 26th of July to look into whether we have imported plastic waste into Hong Kong, which then became stranded in Hong Kong, and also the question of the difference in statistics for imports and exports. So I agree that we should leave the relevant issues for that particular panel meeting. Yes, all members, including non-members, have been invited to the special panel meeting. Mr. Vincent FANG has said that before the relevant issues are resolved, we should not continue with the scrutiny of this bill. But I hope members will understand that we are talking about separate issues. I think we should discuss the remaining issues that we raised in the past about the bill, and then if after we get a briefing from the administration, we should proceed to cross by cross. Mr. Lam, over to you for introduction of the administration's response. There are three issues here. First, inclusive pricing, implication of inclusive pricing. The legal advisor raised 2 points, and we have provided our response. In paragraph 2, we set out that whether in the first phase or the second phase of the PSB levy scheme, although we want to advise against excessive packaging, the policy objective will not really put a stop to the behavior mentioned. And this is not the intention of the bill. If this buyer doesn't really want to have the PSB under this inclusive pricing arrangement, the buyer can, of course, take it up with the seller. If the provision of the PSB is part of the arrangement of sale, then under the second phase, a levy has to be collected. The second point is also about inclusive pricing. Whether it's the first phase or the second phase, well, when we launched the first phase, initially there were some inquiries concerning a retailer making an arrangement which is inclusive pricing. We'll monitor whether this will happen in the second phase. In the first phase, we did not see this extensively practice. Will this re-emerge in the second phase? Well, we have received views on both sides. And when the deputations came, the news vendors also said that a retailer has no incentive to give PSB out for free. And if there's a law to collect a levy, then the vendor has all the incentive to reduce his operating costs. At present, in the regulated retailing sector, they have got a system, training, the IT, and other operational arrangements to include the PSB levy as part of the payment. And they are not going to change it with the introduction of the second phase. We understand that they do have an incentive to maintain the existing arrangement. And on the part of consumers, through the compulsory levy scheme, we provide incentive for them not to use PSB when it's not necessary. And many consumers have changed their habit because of the first stage. If they go to patronize an outlet with no free plastic bag, they will bring their own bags. And we don't think that this presumed scenario of inclusive pricing will change that behavior with the introduction of the second phase. And we have also provided a table to respond to some of the deputations' comments. Members, please note the response from the administration. And anything to follow up here and now, members? Mr. Tony Chair. Of course, imposing a levy is one of the ways to do it. And previously, it was mentioned that under the levy scheme, PSB levy scheme, the consumer has to pay for the use of a PSB, and the retailer will collect the levy. And now it's proposed that they can keep the levy. Of course, the amount of levy is a matter of concern. They may really want to give out more PSBs so as to collect more money. And now the levy, at present, the levy has to be channeled to the government. In the future, they keep the levy. So they may regard this as part of the business. To some extent, the levy can reduce their operational cost. And Chairman, of course, we are targeting plastic bags, and the use of paper bag may be just another problem. So that's another environmental protection issue.
Just like non-woven bags, well, if people are unable to change the habit of using bags in the future, then another type of bags will be used, and it's foreseeable that more plastic bags will be used in the future for smaller individual items. Well, people may get used to bring their own bags, but for larger items like clothing, so far I don't see this habit. Well, of course, the levy may also be one of the factors. And I'd like to follow up on the manufacturers of PSBs. At present, the responsibility doesn't lie with manufacturers. It just lies with customers. So it all has to do with money or levy. If the bag can be reused many times, less plastic bag waste will be produced. But so far, we're not targeting manufacturers under the user pay principle. In fact, they are the ones producing these products, which are undesirable, and we're not targeting them. Well, the bill doesn't cover them. I'd like to know something about this issue. So, Mr. Lam, can you explain to us how producer or customers' behavior or habit can be changed, and also the consideration of the administration in phase 1 of the PSB levy scheme? Thank you, Chairman. Now, it has to do with how we can introduce change in the habit of consumers. And in the first phase, all the charges collected goes back to the administration. But in the second phase, it's not feasible for all smaller retailers to follow this model as well. So after consultation, having heard the views, we need to make a choice rather than collecting the levy from retailers. The retailers can pocket the money so that the consumers' habits can be changed, and this will apply to all retailers. As for plastic bags and other substitutes, we observed during the first phase that all retailers under this phase 1 of the scheme, as we understand, did not show a prevalent trend of consumers using paper bags instead of plastic bags. We don't see many retailers substituting plastic bags to circumvent the regulation, probably because plastic bags can be reused many times and there are cost implications if plastic bags are used. Now, the scheme aims at changing consumers' habits, As for manufacturers, the member is correct. At the present stage, there may not be direct impact on manufacturers, but we have indeed collected views during both phases of the scheme, suggesting that for manufacturers, they do not need to shoulder any responsibility. But according to some feedback, we understand that demand for the plastic bags they produce has fallen. Follow up, decreased in demand. To what extent? So, of course, it's the best if you could provide us with some data. Now, it's a levy for each plastic bag used. A levy would be charged. Well, perhaps you have thought about that before. I didn't quite notice. How about giving a discount? Let's say if you don't use a plastic bag, can you deduct any money from it? Well, Mr. Chair talked about this issue. In fact, the BYOB has been publicized for more than a decade. And in the past, some retailers have been providing discount or concessions for customers who do not ask for plastic bags or bring their own bags. This is the education and publicity effort 10 years ago, and it's time to take a step forward. So I believe it's more difficult. It's much more difficult for this to be introduced in not just in Hong Kong but in other countries as well. So let's move on to the clause-by-clause scrutiny stage. Mr. Ho, sorry I didn't see your hand. Chairman, our concern is that once the administration doesn't collect the levy, then the government will not be able to get any data. Now, I'm thinking about different ways to monitor the figures. Now, according to the administration's paper, they are of the view, or they believe, that the pre-levy mode will not re-emerge, but then this is just their belief. You need to have empirical data to verify the situation. That is why we need a way to check whether the number of plastic bags distributed have increased or decreased. The second stage will cover, or second phase will cover more retailers apart from supermarkets, including bookstores and food shops, etc. And some other bags like flat top bags will also be covered. So it is very important for us to find a channel for collecting this data. I understand that the administration will not move a step further, but please come up with some ways. Consider getting some information from the plastic materials importer, because custom clearance or customs declaration is required. So can the administration coordinate matters with the Customs and Excise Department so that accurate data can be obtained for plastic bags imported into Hong Kong? We can then use the pre-levy mode situation as the benchmark, and then we can look at the economic performance of that year together with the number of plastic bags or plastic materials imported, and then do some analysis so that we can see whether the scheme has been successful in changing consumers' habit of using PSBs, or whether the old trend is re-emerging. That should be a target. For example, there should be a review once every 2 years. The problem is, without data, there is no way we can start. So, Mr. Ho, you're saying that either it's done by legislation or by administrative measures so that we can monitor the change in the general public's habit in the use of PSBs. Yes, I mentioned that. I say that if the administration refuses to move for CSA, I will do it. But definitely under the split voting system, the CSAs will not be passed. Okay, please refrain from having a dialogue between yourselves. So it's so difficult to amend the law, and if we're unable to persuade the administration to change, then at least administratively we should try to persuade them to change their tactics. In fact, just like import and export of waste, in fact, there is a way to monitor the situation if we plug the loophole. So here, I ask the administration to monitor the plastic bag importers so that, and also the manufacturers. Well, let's see what the administration thinks. Even if this Bills Committee starts clause-by-clause scrutiny today, we are going to go into recess during summer holiday, and we'll come back in October. So there is still time for the administration to consider whether any change should be done to the bill. I don't think this is just a point raised by one member, but the whole Bills Committee. So, Mr. Lam, can you say more today to reassure members and also members of the public? Chairman, thank you, and I thank Ms. Ho for her suggestion on import data. She's asking whether we can get some data and then compare the situation 2 years down the road and look at the trend. But as we said before, the import data doesn't really show the whole picture. But still, we agree that taking a reference point and then comparing a trend may be feasible. Well, in order to assess the effectiveness of the second phase of the PSB levy scheme, apart from other channels, I mean, basically we're going to continue with the survey which we have been conducting during the first phase to gauge the change in the general public's habit. Now, another useful data is the landfill. We look at whether after implementation of the scheme, number of plastic bags disposed at landfills have increased or decreased. We have started to look at it since the first phase. Some bags may be reused, some may be stored, but in the end, we look at how many bags are at the landfill, and this is a survey that we do every year. Our ultimate goal is to reduce the number of plastic bags being disposed of. Sorry, speaker's not using the microphone. I think we have asked the administration many times. They have given us the same reply many times, so it's getting a bit meaningless. The most important thing is we raise the points here and see how improvements can be made at this clause-by-clause stage. Chairman, I'd like the administration to elaborate on his reply to Ms. Ho's question. He says the import data does not reflect the full picture. So you're referring to the Mr. Lam's reply. Okay, he said the import-related data doesn't reflect the whole picture. On what basis can you say this? Because what he said then is the accurate data should be the data obtained from the bags disposed of at the landfill. Well, I think that the number of bags at the landfill is accurate. Well, about this suggestion, I think that this is just a guesstimate. Whereas for import data, this is accurate because customs declaration is absolutely necessary. whereas there is no way you can get an accurate data at the landfill. Well, yes, you can follow up on the question, but we still have 2 members waiting in line. So, Mr. Lam, please elaborate on your answer. Thank you, Chairman. Thank you, Mr. Wong, for the follow-up question. Just now, I said that in order to look at the number of plastic bags used or plastic bags distributed, the imported, the quantity of plastic bags imported, of course, is important, but not all of the bags will be used in within a year. And also, there are local manufacturers, and we need to include all these figures. And at present, we don't keep the statistics, so it's not a full picture. Well, the thing is, you don't have the statistics. It doesn't mean that what you said is true. I am from the C&I sector. I can tell you that there is no local PSP manufacturer in Hong Kong. It's 100% imported. So you should be responsible for what you say. And what you said just now is just a wild guess. Can you tell me which factory, which factory is a local PSB manufacturer? It's just a speculation. Tell me the name. Tell me the shop sign to convince me. But you cannot tell me that.
Mr. Lam, that's what I said. We did not keep statistics on local manufacturers. But then you shouldn't say that you miss out on Hong Kong manufacturers. So we don't have the statistics. That was what I was saying. All right, so members may wish to put questions to the administration, leveraging on your own background information and expertise. I know that Mr. Vincent FANG has written a letter to the administration. On Friday, we are going to have the special panel meeting, so I would like to get some answers on the following questions. Have we actually imported waste from abroad, and how much of that is plastic waste? If we want, on the one hand, consumers to use less plastic bags, but on the other hand, we import a lot of plastic bags, plastic waste plastic bags, then we have a very irrational policy. I think to start with, we should forbid the importation of waste from abroad. Otherwise, why should you be pinching our own people and ask them to pay this levy and that levy for using PSPs? So we need to clarify whether we have any loopholes in our law that allow importation of foreign waste and foreign waste plastic bags. Then the first thing to do is to plug the loophole and prohibit that under our laws. And many members have asked for tracing or keeping track of imported plastic shopping bags. You have said that you have no statistic. Well, but then we are going to have a serious loophole in the PSP levy scheme, because the retailers would keep the collected levy. If the levy has to be given to the administration, you would keep the statistics, or if you require the levy to be used for environmental protection measures, you also keep statistics. But without the need to keep track of the levy, then there's no statistics, and we don't know whether the problem is improved or not. Well, I think this question about Mr. Vincent FANG is also our concern. There was a special meeting for the EA panel. So I think we better leave that particular item, importation of waste, imported waste plastic bags, for that special EA panel meeting, and this Bills Committee should concentrate on the bill. And that's why your second question is really relevant here, and that is how can we monitor the importation of plastic bags and where they go. I think the administration has responded to the same questions more than once on the question of designating some special purpose for the expanding the collected levy. Maybe you can supplement, Mr. Lam? Well, nothing much, Mr. Chairman. The mainstream view is that we should expand the coverage of retailers under the PSB levy scheme. And if we want to extend the coverage, we have to make a choice. If the levy has to be channeled back to the government, small retailers may find the required changes rather unacceptable. So we have make a choice to allow them to keep it. Sorry, Ms. Priscilla Leung, first. I want to put on record something here. I raised the proposal of a dedicated use of the levy collected. SMEs may find it difficult to comply initially, but I want to put on record my request, my demand that the collected levy should be used solely for environmental protection purposes. With the scheme extended in scope, there are people who are disadvantaged, the elderly, the poor will be adversely affected. If 50 cents is still too high for them, or if they have to pay 50 cents a few times, it's a bit harsh on them. So how are you going to help these people who are not able to really afford it? That's the worry that I have heard from my contact with the disadvantaged. Mr. Lam, maybe I should skip the first question. The second question is about what are we going to do for the needy? What assistance can be offered? Actually, the same comment was received in the first stage, and that is to say the same in the first phase. There were also people who had to go to supermarkets and use PSBs. Actually, some organizations did extend a helping hand to them, to the needy. And at some stage, we said we should not give out too many so-called environmentally friendly shopping bags. If they have their bags, they can keep the bags and reuse them. There is no need for them to pay the PSB levy. Of course, there are exceptional circumstances, and there are other containers which they can use to buy grocery or fresh produce, and the containers or bags can be reused. You need to do something more in order to facilitate the change of consumers' behavior. Usually, people will give out so-called environmentally friendly shopping bags. Are you going to identify those who are in serious difficulties? For example, the homeless. And now, if you give them a bag, you should advise them. You should reach out and advise them that the bag is supposed to be reused. Otherwise, in the future, they may have to pay the levy every time they shop. So are you going to reach out and do some publicity and at the same time offer assistance to these people? Mr. Lam, thank you for your comment. We can consider this. But the comment that we have heard is that usually in a family they do have too many rather than too few shopping bags. I hope the message can be sent out to reach everyone. Yes, the message is important because and right now those people who don't need these shopping bags are getting more. But some elderly people or those who are ill do not know where to get environmentally friendly shopping bags, and you should try to help them. Dr. Lo Wai Kwok. I think I may be repeating some of the points made by colleagues. I think their worries may not come to pass. There's no need to be too worried. Recently, we have had many discussions about the land use, and therefore people are attaching more importance to the reduction of waste at source. This bill is not really about the extent to which we can reduce plastic bags from being disposed of in our landfills. But in the first phase, I would say it was a success in that it provided good public education. So I'm not afraid that in this phase we are going to lose public support. From my personal experience, some smaller shops are already prepared, and they are taking the opportunity to inform their customers in advance. I think Ms. Priscilla Leung has made a good point that those singleton elderly people may not have access to free environmentally friendly shopping bags. I believe district councillors and members may do more to help out in the constituencies. Actually, I myself prepared shopping bags made of woven fabric. When we were young, we used a rattan basket to go to wet market. And I think people are very resourceful, so we don't need to worry. Plastic bags are wreaking havoc to our ecology. If they end up in a landfill, that's already the better of a few other alternatives, because if they are disposed of in the wild, they may affect the ecology, the soil. But I think we should not mix up the bill's objective with the importation of foreign waste. Let's proceed to the cross by cross expeditiously. Mr. Chan Hakan, we have had a few meetings and we have conducted a public hearing. I believe the administration is aware that there's a strong voice calling for the 50-cent levy to be used for dedicated purposes. At present, the shops have to channel the collected levy to the administration, and in the future they don't have to do this. Although they may say that they will use it for environmental protection, there's no guarantee. Well, would they be asked to sign some pledge or agreement, something in black and white, to assure the public and members here that the levy collected in the future will be used to protect the environment or to support initiatives for the same purpose. Otherwise, it's just empty talk. If you can work out some sort of agreement with these shops, then it will be easier for the bill to receive the necessary third reading. So that's also what some green groups are asking for. Secondly, so far you have just received 11 complaints concerning the PSB levy. When the levy scheme is extended, I expect the number of complaints to go up significantly, and some shops may abuse the system, or they might refuse to collect in accordance with the levy in accordance with the law. With the law in our statute book, you must enforce the law strictly. How much manpower and time have you expended in handling the 11 complaints? I'm concerned that in the future, with more complaints, with the extended coverage, you don't have the manpower to handle the complaints. It's just like the Tobacco Control Office case when they don't have the manpower to investigate.
Now about Mr. Chan's first suggestion, that is, during the second phase, will those retailers who collect levy use the money collected for environmental protection related objectives? And we have discussed with the major retailers, and they've openly agreed that active consideration be given to the suggestion. And some green groups have already begun discussion with them. And once this bill takes effect, they will come up with some concrete proposal. But before its implementation, or before its full implementation, they have also said that they would not come out and announce a way forward. Well, there have been media reports, and this issue has been discussed. I think the next step may be to sign the relevant documents. Now, about the 11 complaints, we at present have a dedicated team that deals with investigation or, for example, sting operation or the gathering of evidence. We have new colleagues on the team now, and when second phase is implemented, we are going to retain the manpower, and we're also going to deploy more manpower to the team. And as said by Mr. Chan, this is a education and publicity effort, as a preventive measure. What we do is to educate the general public and the retailers on the new requirements, and once the bill is finalized, we're going to make this effort via different media channels. On legislation and deployment of resources and manpower, etc., I don't think it's a concern. We'll make sure we have sufficient manpower for the operation. Anything to supplement, Chairman? May I briefly explain the situation? Now, the member's point is about the question raised at the meeting. But as far as education is concerned, apart from media advertisements promoting BYOB, we also have a hotline. We take active patrol work, and in some cases, the complainant can be identified. So altogether there are 11 complaint cases. As for the total number, I don't have the information at hand, but I think the major objective is education. Some queries may have to do with some clarification on the first phase of the scheme, what retailers are involved, what will be the penalty, and some shops would also like to seek guidance on or advice on a certain scenario. So we have more inquiries received than complaints during the first phase of the scheme. But after a while, as this has become a regular habit, we are seeing a fewer and fewer complaints, and we also have routine inspection. Mr. Paul Chairman, I don't know whether we're approaching the end of the session or we have actually ended the session. I find it quite difficult to read. Now, about the legal advisor's question raised last time in the second batch of the papers, well, I don't know whether we have covered this morning. About G, Romans, small letter 1 and 2. Now, 1, 2, 3, 4. These four paragraphs in the administration paper try to answer the legal advisor's question, but I really don't see how the answer relates to the question. Well, last time we mentioned that if the customer wants to seek a refund and the seller refuses to give the refund, he may be prosecuted. And I'd like to know about this, because for 18(2) and 3 in the bill, the penalty levels, it's level 6. $100,000, and the second conviction $200,000. So the penalties are quite serious. Well, as is the government, we going to withdraw this sentence of using it as a piece of evidence for prosecution. Maybe I'll invite Mr. Lam to respond to your question. Last time, the legal advisor raised a question based on a hypothetical situation, and we gave the answer on this basis. And in fact, here we have a detailed answer. It's an improved answer, so that under various scenarios, what would happen. In paragraph 2, about the legislative intent, well, as to whether inclusive pricing can help curb the situation, as mentioned in phase 1 and phase 2 of the scheme, what we want to do is to avoid excessive packaging. Now, and for adducing evidence, we have given consideration. It's very hard to explain. It's not easy to explain the situation, although we attempted to do so last time. So it's a matter of the customers making choices. The customer, on seeing a plastic bag, may request the seller to give a refund and refuse to take the plastic bag. The customer, that's on the customer side. For sellers, we also explain that you can sell the item along with the packaging as an intact item. So we explore whether consumers can refuse to take a plastic bag, and whether sellers can also do the same. So we have explained about it. So how will this law be enforced? A refund can be done on various excuses. That today's weather is good, so I give more discount for refund, or refund for return of plastic bags. Well, Chairman, in order to assess whether the retailer has the incentive to do this, during the first phase, we learn that they also need to look after a number of situations. They may not necessarily or have the incentive to indiscriminately distribute bags. If the pricing changes too frequently, the seller will also need to consider the customer's response. And for education, the attaching importance to trend of BYOB and what the law says is that if you purchase an item and if you want a bag that comes with the item, then you need to pay. That's the levy. As I understand, during the first phase, because the retailer has the responsibility of reporting the levy collected, all these should be properly recorded or documented, and in the receipt, this must be stated. In the second phase, instead of a mandatory requirement, this is a voluntary task, and the administration may also find it hard to enforce the law. So is it safer to not legislate but provide incentives instead? Well, Mr. Chair, in fact, I also made similar queries as I first read this paper. But if we scrutinize provision 8 or clause 18, I think by then we will be able to take a more focused approach when we discuss with the administration. We have been asking the administration for an answer since May, and this is what we get so far. So as a responsible chairman, I say that we should either suspend the meeting until the administration improves the situation, or we wait until that part of the bill where we can focus on the issues involved. But may I invite the administration to say a bit more on this so that members also get an idea, and then when we reach clause 18 we can discuss with the administration on the drafting improvements. Legal advisor, please. Well, thank you for allowing me to explain to you my position. In relation to the written reply from the administration, same as the last time, some provisions or clauses are cited, and the administration has interpreted on the basis of some scenarios. According to clause 18, now it says here that some of the bags will not be subject to the regulation. Well, but members understand that there are three major components. One is 18A. 18A provides a legal framework under which the retailers have the legal responsibility to collect levy from consumers. The second part is about levy on certain items of fixed penalty. The third area is is about exemptions. Now, if members find it appropriate, when we reach the clause-by-clause stage, we can look at this paper from the administration again, and then we can check it against the bill and see if their interpretation is correct, and see whether there are further questions. Then we can invite the administration to explain the issues. Now, for 18, like I said, when we reach the schedule in relation to exemptions, you should find that some conditions are also included on top of the features before you can say whether the plastic bags are belong to a certain type of bags. and if necessary, I can further supplement. Thank you, Chairman and Legal Advisor. I want to give a warning now. I find this 18 capital A policy hard to accept, and I can't accept this provision. I hope the administration can do more in improving the drafting. All right, I agree. If members have no further questions on the government's policy and the administration's response, I will then start the clause by clause examination. Now, you may wish to refer either to the Chinese or English version, but let's look at CB bracket 11171 bracket 01/1213. This is the marked up copy, and you can see the parts that have been added or deleted. This will be the basis of our discussion, and if necessary, members may also refer themselves to the blue bill for cross-reference. Administration, please. Chairman, may I ask members to refer to the paper that you have just read out. For clause 2C, clause 22C, we are proposing an amendment. It should be D, in fact, about the environmental levy. In this amendment exercise, as the 50% no longer has to go back to the government, it's not considered as a levy. So it's a technical change. This provision shows that levy can still be imposed on the basis of this provision. Any other views? Mr. Ho. Now, when we talk about the policy, we say that you can cancel the levy and the charges will be collected by retailers. So, well, it's not that I'm against the environmental levy, but I would say you can leave it status quo. But what is the reason behind this change? Why can't you keep the word levy? Chairman, this provision sets up the same framework. This is the basis of introducing product equal responsibility. And on this occasion, for this amendment exercise, this is 2AE, and it's not covered. This doesn't cover the scheme. But for other environmental levy, this can be done using the same framework.
What other levies are there? Well, the only levy is on PSB, but with other producers, product eco responsibilities, ordinances, we are going to cover other levies. So there's no reason to delete the reference to environmental levy here. Of course, we want to have producers' eco responsibility, so we're in favor of environmental levy. But I don't think this is the right way to do this. At present, we only got one levy, the levy on PSP, and now we are in the fourth meeting. We are told that the environmental levy will be deleted to be replaced by a charge. But now we want to keep this in the framework. We want to keep this reference to environmental levy in the framework legislation. Is this really an attempt to ban the rules? Well, in the future, there will be products to be covered by this framework legislation. And they have to come back to discuss with us whether it's going to be called an environmental levy or charge or whatever. Mr. Lam, maybe you can explain further what this product eco responsibility ordinance is a framework legislation. Whenever we want to cover a new product, there will be a fresh piece of subsidiary legislation. And then there are different designs for product eco-responsibility. You can take a look at 2A, B, C, D, E for different measures or schemes to be introduced. So actually, a variety of approaches is allowed. And we have made reference to international practices. For example, a deposit or deposit refund scheme and so on and so forth can be implemented. So far, we haven't got any such schemes, but it's allowed under the framework legislation. We think that in the framework legislation, we should cover all the possible measures or schemes that we may launch. That's the spirit of a framework legislation. 2.1a, they mentioned plastic shopping bags. Now instead of a levy, we are going to have a charge, and it also covers vehicle tires, electrical and electronic equipment, packaging materials, beverage containers, and rechargeable batteries. Is it true that we have not introduced any levy for all these products except PSB? Well, I've sold my car. I haven't bought any vehicle tires for a long time. So do we have anything for electrical and electronic equipment? No. Packaging materials? I don't think so. Glass bottles? Might be. Rechargeable batteries? Nothing so far. So when you enacted the bill back then, you provided for so many products, and so far you haven't done anything about these other products. And you think that you must keep the reference to environmental levy in the framework legislation. Then my question is, in respect of vehicle tires, electrical and electronic equipment, packaging materials, beverage containers, and rechargeable batteries, when are you going to do anything about them? Why are they put in the law? Well, in accordance with Article 45 of the Basic Law? Well, when the bill was enacted, there was a wide discussion on what should be covered. And that's what you see now is the final version. My understanding is that it expresses the intention on the part of the administration to consider whether some scheme should be introduced for these products. And internally within the government, we have proposed legislative proposals for electrical and electronic equipment. We have done public consultation. We have also completed public consultation on glass bottles. As for products not covered in 2.1a, are we going to do any of them? Well, possible. In the past, many vehicle tires were disposed of in our landfills, and that's why we wanted to reduce the disposal of vehicle tires by introducing product eco-responsibility schemes. But time has changed, so some of them may no longer require special measures. So we have been asked by many people, including members, about the progress of different eco-responsibility schemes. We are drafting some legislative proposals. We hope we can present them to this council as soon as we can. And for another product, we've just completed public consultation. Well, I just find it unsatisfactory that the government tries to get as much power as possible, but with so much power, they are not doing a lot. We cannot just be asked to give you the power, but we cannot really force you to move quickly. With the power, you must act responsibly. Well, the government administration would say that they would roll out measures one by one as soon as they are ready and mature. So, in respect of other products, maybe the administration should give us a clearer timetable. Dr. Helena Wong? Thank you, Chairman. In 2(1)B, it refers to the polluter pays principle, and that it may require manufacturers, importers, wholesalers, retailers, consumers, or any other parties to share the responsibility for a reduction in the use of all these products, or to share the responsibility in recycling of the products. But for the PSB levy, you're only going to do something, you are going to require the consumer to do something. In the original provision, it's a shared responsibility covering many parties, manufacturers, importers, wholesaler, retailer, consumers, and other parties. So it's in 2(1)B. The way it's worded is fairer, but now for PSB levy, you only regulate the consumer. What about the manufacturers, importers, wholesalers, and so on and so forth? Why can't we mandate that importers to pay something if the packaging is excessive? If you have more than 2 layers, well, I think in some countries they have similar, or they have some rules about this. I just don't understand why in Hong Kong we only regulate the consumer's behavior. A fairer approach is to have the responsibility shared by some other parties, including manufacturers, importers, wholesalers, retailers, if the packaging is excessive. Shouldn't their behavior be regulated as well? Well, in relation to excessive packaging, I think this is not the first time the issue is raised, and I have actually responded on various occasions. Let me stress that the principal legislation is a framework legislation. The design is such that it doesn't target any specific product. When we focus on PSB, we would provide specific arrangements through different provisions in the law. And back then, some members asked whether we should have standalone ordinances or tailor-made ordinances for different products, or rather it would be better to have a framework legislation. It was decided that we should have a framework legislation and then come up with focus arrangements for different products. With the framework legislation, we cannot introduce or expand the coverage indiscriminately. Every time we extend the coverage, we have to amend the principal legislation and to have a specific subsidiary legislation as well. And that was what transpired in the discussion of the framework legislation. Chairman, I don't know whether you would like to revisit all these issues in the framework legislation, or should we be more focused and look at how we can implement the PSP levy schemes? Mr. Lam, I think members have the responsibility to act as the goalkeepers or gatekeepers for the public, and that's why they will have to ask questions about the progress or the coverage. The administration has been providing the answers to similar questions. Although you may be repeating the answers, is still a good thing for members to understand the background, because you want to add more products, glass bottles and other products would be covered later. So I think the questions are raised for good reasons, and I hope you don't mind. And still, we have got time. We are going to continue after the summer break. And I would like to encourage all members, me included, to do our homework properly. Dr. Helena Wong, any follow-up? Well, but I haven't heard the answer to the questions about excessive packaging, and why haven't they looked into this? I'm talking about imported goods, imported products. In some other countries, they do have similar regulation. I do understand that the concern is about excessive packaging, but we have to look at the provisions to see how they can be applied to regulate excessive packaging. Well, the bill targets only retail outlets, and in the case of the customer who wants to get a PSB, apart from wet goods, so the only party regulated is the consumer. But the idea behind this product eco-responsibility ordinance is not just about regulating the behavior of the consumer, and also it doesn't just cover PSB. We have vehicle tires, E&E equipment, packaging materials, beverage containers, and rechargeable batteries. And also we have to look at the source of the pollution. It's not at the point of the retail shop where the consumer gets the PSB. It has to do with the manufacturer's production strategy. If instead of one layer of plastic, they have 2 layers, then you have more plastic waste. If we ask the consumer to pay the charge or the levy, then the consumer may retort that why do you allow products with excessive packaging to be on sale in the market? So are there countries regulating over packaging? The answer must be yes. If they can do it, why not Hong Kong? And then you can tell people that we're very fair. If they are doing it, if providing excessive packaging, they pay something. And if you ask for a plastic bag at the retail outlet, you are also required to pay a charge. And you are it's just equal treatment. It's just like why people are asking for part of the golf course to be resumed for new developments. So why don't you consider the manufacturer's behavior as well? I would think that the bill would be more balanced and comprehensive if you regulate both ends of the process. It would be more convincing. And of course, the likelihood of it getting passed is higher.
Well, Mr. Lam, I know what answer you will give, but anyway, please go ahead. Chairman. Maybe I'll try to give the answer that you have in mind. This is a framework ordinance, so it contains all the methods mentioned about the polluters pay principle and producer responsibility schemes. So when we talk about producer, we talk about producer of waste. So they can be manufacturers, importers, wholesalers, retailers, or consumers. So does it mean that for each product or each producer responsibility scheme, the different levels in the chain can all shoulder the responsibility? Now the situation is quite unique. During the first phase of the PSB levy scheme, some suggested that consumers needed to shoulder more responsibility. But in fact, plastic bag manufacturers also said that the demand for plastic bags have dropped. So I can't say that they're not covered in the scheme, and this is what the framework ordinance is about. Not all written here may be implemented. If we look at other jurisdictions, in some producer responsibility schemes, they may only cover retailers but not manufacturers. So we need to look at the design of the individual scheme, and if the charge or levy is to be imposed at a particular level in the chain, does it mean that the level will be shouldering 100% responsibility? According to experts, there will be a financial burden on both the level above and below the target. So they're also affected, but not all schemes can cover all levels. Well, about excessive packaging is mentioned. It is our concern, and the legal advisor also reminded us again that tax in Section 18. Well, consumers may think that it is not their responsibility for paying $1.50 for 3 layers of packaging. So this is an issue when we talk about when we go to the clause-by-clause scrutiny stage, and when we reach Section 18, I think we should rethink this part. Ms. Sit-ho, I'm sorry for opening this can of worms. I agree that this is a framework ordinance, but we're talking about expanding the framework. Apart from levy, we also introduced a charge. So a follow-up question, Chairman. Now, in the future, for different products, how can we prevent the administration from changing the levy to charge? Now, apart from Section 18, there are other provisions related to plastic bags, and these cannot be changed easily. But my concern is that this administration likes to gather all the authority and power first, and for the negative vetting procedures, when by that stage they can do whatever they can. So, Chairman, for this environmental levy or charge in 22D, can they tell us in future how they will decide whether a levy or a charge should be imposed for a particular kind of product? Because there is huge difference in legal terms, and for a change from the charge to levy for a particular product, what procedures are required? I'd like the administration to tell me. Well, I know this is not happening yet, but we need to prevent the administration from getting all the powers and then making amendments using the negative vetting procedure that circumvents the electrical's control. Mr. Lam, as I understand, this is the framework ordinance, and for each producer responsibility scheme, amendments to either the primary ordinance or the subsidiary legislation would be required. And you may recall that when we scrutinized the Product Eco-Responsibility Amendment, the bill, we agreed that the administration should not proceed with any PRS with negative vetting procedures easily because of electrical objection. And that is why whenever we roll out a producer responsibility scheme, we table an amendment bill. So about the number of schemes mentioned, if there are more schemes or less schemes, which provision provides that part? I think legal advisor has read through the bill. Maybe she wants to retrieve the relevant provision for your reference. Now, Chairman, you said that when we come to Section 18, we can then deal with the problem of excessive packaging. I didn't say we can deal with the problem of excessive packaging. Mr. Paul Chair also asked a similar question just now. He wasn't happy with the administration's answer as it is. So what we do is we start clause by clause scrutiny first, and when we come to clause 18, we can then look at the drafting prospect and see how improvements can be made to ensure that responsibility is shouldered between both the consumers and the manufacturer. Now, but I want to make sure whether the administration is prepared to regulate on excessive packaging. In Guangzhou, Taiwan, Australia, and other jurisdictions, well, they are doing something about it. For example, excessive packaging on red wine. And the Consumer Council is promoting sustainable consumption. They're also against excessive packaging. So if our neighboring jurisdictions are moving in this direction, will the administration do that as well? Can you tell me something about what they are actually doing, dealing with excessive packaging? Excessive packaging, over packaging, you see a lot of examples. Just Google them. In Taiwan, the authority has a website on preventing excessive packaging. You look at the Director of Environmental Protection's website. In other jurisdictions, Australia, Guangzhou, etc., we are heading in the direction of waste reduction. We're doing it by means of imposing a levy or charge. But if you don't regulate excessive packaging as well, it's hard for the public to accept. So you must regulate and tackle the problem at source. In order to reduce waste, before you regulate litter bugs. Of course, consumer can choose not to buy any products with excessive packaging. This is also a means to fight against it. Definitions, according to experts, means that experts say that excessive packaging means using excessive material for packaging the products and with too many decorations, etc., etc. Now, is the administration minded to do it? If you're not minded to do it, then there is a problem with the whole policy of waste reduction. So if we just ignore the policy and go ahead with the minute details in the bill, it's hard for us to give our support in the voting stage. Mr. Lam. Thank you, Dr. Wang, for a question. On overpackaging, at the last meeting, we exchanged our views. Now let's talk about experience in other jurisdictions. As mentioned by Dr. Wang, in Taiwan, there are different regulating authorities for certain products. For example, like a telephone or a telephone directory or telephone book, there are specifications on the number of layers of packaging and the dimensions. They have very detailed specifications for each product. In Hong Kong, we did look into this issue. At present, in our waste management blueprint, there will be various measures to be rolled out. We have also draw reference from other jurisdictions. Some initiatives will be introduced first and some later. Now, Dr. Wang's question is about over-packaging and whether there is a need to legislate on over-packaging. I think that is a matter of our differing views on the priority. I think we all agree that something should be done to stop over-packaging. For Taipei or Taiwan, their experience is that they can introduce waste reduction by charging or levying on waste disposal. For South Korea, we have been told by government officials that because of the waste levy scheme, consumers would return the overpackaged products or materials back to the retailer, or they would prefer other products, and we're looking at how the scheme can be implemented, and whether the waste reduction target can be pushed to a higher level, and before we consider legislating or regulating over packaging. I think it's a matter of priorities. I hope that we all get the consensus that this step is a must. This is the second phase of the PBS levy scheme. We have had an extensive consultation, and this is what we must do now. As for overpackaging, I think as part of the whole waste reduction policy, we hope that by the levy scheme we will be able to minimize or reduce waste. It doesn't mean that we're not planning to roll out other measures, but we want to go ahead with this levy or charge scheme, which has been formulated after detailed consultation. Yes, thank you for the reply. I don't think this is contradictory. And Dr. Wong, maybe you should raise your question again at the Environmental Affairs panel for the administration to do their homework. This is the Bills Committee. It's impossible for us to talk about other issues apart from the bill. And perhaps the legal advisor can answer Ms. Sitho's question. Under this legal framework, what roles do the government play? Legal advisor, please. Well, as members may be aware, if the administration would like to amend the framework ordinance or the primary ordinance, an amendment bill will be tabled at LegCo for scrutiny. Ms. Sitho is talking about some subsidiary legislation. Now, taking this as an example, here, product eco-responsibility amendment bill, and under it there is a plastic shopping bag regulation, and 2 are relevant, and 5 and 29. Section or clause 5 stipulates that after consulting the ACE in relation to some matters, they can enact subsidiary legislation, but only subject to LegCo's approval. For number 29, the Bureau's director is empowered to amend Section 3, Part 3, and I understand this is the framework framework ordinance. Well, actually, number 5, number 29, they focus on Part 3 about plastic bags. As for other future schemes like glass bottles, that means they need to make additions to the framework or the primary legislation. And I believe that it will be done by way of subsidiary legislation or regulation to let the public know how it actually operates.
That will come as a piece of subsidiary legislation. If it's done under Section 29, then the regulation will be tabled in LegCo for scrutiny. Is it negative vetting or positive vetting? Legal advisor? If we look at 29, they would have to table the regulation first, so it's positive vetting. In that case, we do have the power to scrutinize the regulation first. Yes, so we'll be acting properly as the gatekeeper. Next, interpretation is Section 3. It's already also in Part 1, part of the framework. Here we want to add a new item, body corporate. The term will appear in the provisions on penalties. Here we have the interpretation of this term, body corporate. We have A and B, 2 limbs. Ms. Sitho, sorry, I have to ask questions about the detail. Do you have any definition on levy vis-a-vis charge? Any difference between the two? Your question again? Maybe if our legal advisor can help. My question is, what's the difference? Because a levy is different from a charge, and we want to change the levy to a charge. Do we have a definition? So are you suggesting that there should be definitions about levy and charge? Well, I'm asking whether there are definitions, because the whole idea is about replacing a levy with a charge. So is the difference clear? Ms. Ho, we can look at the ordinance. The DOJ representatives can supplement. As I can see, there are no definition on the interpretation of levy and charge. I think the ordinary meaning is relied on. And now they want to introduce a charge. The retailer will keep the charge or the payment. But for levy, it's something you collect on behalf of the government, and that's the nature of a levy. You have to pass on what you have collected. But I see no definition about either levy or charge. Well, a levy is a kind of tax. Usually it's collected by the government. A charge is a general term. May or may not have to do with the administration. We do have a definition of charge. It's in section 17 to be amended. It's an existing section. Or you can look it up in the dictionary to see what a charge means. Here, a levy has a definition. It's a levy collected by a retailer, the PSP, environmental levy collected by a retailer. Here, the definition is not about the levy itself, but what kind of a levy has to be handed over to the administration. It's not not a definition. Yeah, it's under section 17. It has a meaning, special meaning. And now we have something new. We have to differentiate the two clearly. In section 17, levy means a levy mentioned in section 18, bracket 3. As we proceed in our cross by cross, let's see whether we can have something that would explain clearly what is meant by a charge. Because in the framework legislation, you have two different terms, a levy and a charge. And now you want to empower the retailer to impose a charge or collect a charge. So it should appear somewhere. Well, there must be something to that effect. Otherwise, we don't know what the charge is about. In section 17, we have this term, levy or PSP levy. We are going to have some amendments. Maybe we can go to the details when we proceed to that part. Maybe the legal advisor can put down a marker and remind us of that when we come to that point. Next, section 7. It's in part 2, part of the framework legislation. Here we add the word charge. It's for the same reasons as those for Section 2. We are going to amend Section 7 bracket 2 and Section 7 bracket 3 bracket B for the same reasons as those referred to in Section 2. Section 7 is also about the submission of information, and if you add charge here, does it mean that the administration reserves the power to ask for information to be submitted, or you can check the records to ascertain that the provisions are complied with? We said that it was a lot of trouble, that they would have to keep all sorts of information. Do they have to keep all the proper records for your purpose? Because you just add the word charge here. Does it mean that they have to keep all the records? Well, Section 7 is part of the framework, so it's not specifically for PSB charge. If you look at 7 bracket 1, it talks about information or records to be kept in accordance with this ordinance, when we do not require any record to be kept in relation to the charge, because that's not required, and there's no record to be checked. So it's in line with the explanation we have been offering that no records will have to be kept. The question is, do you have the power to ask for the records to be kept? How can you assure the retailers? Let me try to interpret your question. Or would you rely on Section 7 and ask why you haven't kept this record? In the first phase, there are certain requirements concerning record keeping and handing over of the levy. So it's not specific, as you have said, requiring what has to be done. Well, if you're required to keep some records, then government officers can check the records. But since in the phase 2 of PSB levy scheme, there is no such requirement. So there's no question of asking for the records to be checked. So it's presumed, although in the framework you have this power, you have to specify that something has to be done. And if it's not required, then no such record is to be kept, notwithstanding the power of, under the framework for the record to be submitted for inspection. I think that's the premise, and that is when someone is required under the ordinance to keep certain record. And now, since no one is required to keep the record or document, there's no basis for the records to be kept, since no one is required to do this. So there's no duty to do it, and as a result, no one can therefore ask for the record to be presented for checking, because no record is required. Sorry. This is a framework legislation. The principal ordinance is about plastic shopping bags. It is expected that by the administration that other products will be covered. So they have to be general. They have to put in place powers that would be applicable to other products. And they are going to delete everything specific about plastic shopping bags, but retaining everything that form the framework, so that in the future they don't have to come back and change everything back to what it was previously. Well, because in some provisions, some records are required to be kept in relation to PSPs, but now those have been deleted, right? Well, we'll come to that later. Well, this is the product eco-responsibility scheme for PSP. This is the framework in part 1, and then general provisions, powers, enforcement. All these are general powers within the framework. As for PSP, PRS, in relation to plastic shopping bags, is in part 3. And we are going to change part 3 extensively, because instead of a levy, we are going to introduce a charge. And if certain information has to be kept in the past, we would set out in part 3 on what is required, and then we'll invoke the general powers in parts 1 and 2. That's the spirit behind a framework legislation. And when we look at phase 2 of the PSP levy, when someone wants to ascertain what has to be done, they will have to refer to part 3 on to see the latest requirement. In part 3, everything will be set out clearly. I think the legal advisor has spelled out my biggest worry. And that is that they don't have to come back to talk about changes in detail for other products. I don't think that's what she meant. She'll be able to tell you more later. In part 2, they will be talk about general powers. Yes, the framework.
But the problem is, under this general framework, we only have one PSP levy scheme, and there is a major difference in the PSP scheme with other schemes in that you don't need to report and keep records. So about the powers to obtain information, retrieve records, etc., none of this applied to the PSP scheme. This is the contradiction that we're seeing. So, what is the problem? The problem is about the future of the legislation. If we designate Part 3 to regulate plastic bags and Part 2 as general provisions, then I think the DOJ should really think ahead. When we scrutinize the framework legislation, it was very easy. But when it comes to the amendment bill, we already find a difference between the scheme and the general framework. Then it will be more problematic if in the future we have other schemes, because we will be adding components to the bill. Are we going to accept Part 3 as plastic bag, or Part 4 as glass bottles, or other ways? Will that be more confusion? Would you like the legal advisor to clarify her position first, or would you like the administration to reply to you? Maybe I'm being a bit arbitrary. Maybe legal advisor can just tell me that's what not she meant. My question is actually directed at the DOJ. in the foreseeable future, we see the glass bottle scheme coming. So for newer schemes, how can they be put under the framework legislation? Mr. Lam or Government Council, can you explain about this framework legislation? Now, we're also preparing the legislation on waste, electronics, and electrical products, and it will undergo consultation, and we're going to add this part to part 4. And what I said just now would apply to part 4, and those applicable to plastic bags will not apply to waste, electrical, and electronic products. Next part, appeals. Chairman, Section 13 is also part of the framework legislation. And 13.1, 13.2, in relation to the first phase of the PSB, the appeals mostly have to do with registration matters, and they will be deleted. And for a short period of time after the scheme is added, no appealable matter would be necessary. So here we've added this appealable matter, which means that they can appeal to the appeal board, and the definition of appealable matter is set out in Section 2. As for waste, electronic, electrical appliances, there are other appealable matters like licensing and etc. apart from registration, and this can be dealt with under Section 13. Part 3. Chairman, Part 3 is about the PSB PR scheme. Section 17 sets out the interpretation and definition of terms. Most of them are obsolete. Many of them talks about registration or certificate of registration, and in the second phase they no longer apply, so they were deleted. On the other hand, we have included definitions for demand note, fixed penalty, penalty notice, etc. Any questions? No. Next part, Division 2. Mr. Lai. Division 2 is one of the major components being amended in this exercise. Now, because of the change in the registration of prescribed retailers and the change of charge instead of levy, Division 2's title will be changed, and we have added 18A and the following provisions. 18A is about duty of seller to charge for PSBs. This section applies if there is sale by retail of goods to a person, and the charge should be done by way of that listed in Section 18A. It should be sale by retail. 18A. At the moment of sale of goods, or at the time of the sale, or if it's for promoting the goods, if a plastic shopping bag is distributed, then a charge should be collected, and as in Schedule 3 at a cost of 50 cents. And it also sets each or a pack of plastic bags. Now for garbage bags, for example, even one garbage bag would be regarded as PSB, and in order to avoid charging each and every bag in such circumstances, we improved the drafting by saying that 50 cents would be charged for each pre-packed pack of 10 or more plastic shopping bags such as garbage bags. We have considered the fact that the charge can be circumvented by just bundling 2 or 3 bags together. And also 18A3 stipulates discount, and 18A4 stipulates that if something can be easily turned into a plastic shopping bag, it will be regarded as a plastic shopping bag in order to prevent the indiscriminate distribution of PSBs. And then 18A5 sets out details about sale and sale by retail, and I'm happy to elaborate on these points should there be questions from members. So let's look at the various provisions in Section 18A. Any questions from members? Ms. Lee? Now, I'd like the administration to clarify this point. For 18A, the administration mentioned that the seller must charge a customer an amount not less than that prescribed in Schedule 3 for each prepackaged pack of 10 or more plastic shopping bags. And the amount is now set at 50 cents, right? So in that case, I'd like the administration to look at Schedule 2. In fact, Schedule 2 it's also subject to amendment this time. And Schedule 2 sets out the types of plastic bags to which this ordinance doesn't apply. According to existing legislation, I'm going to state the following 2 points. And if the bag is classified as one of the 2 points, and it will not be regarded as a plastic bag. That is one that is wholly or partly made of plastic, or that it's all. I mean, if it's already sealed, then if it contains either unpackaged goods or more than one piece of goods, or is sealed before the goods are supplied. So these are the bags to which the ordinance doesn't apply. So here it says that it talks about each pre-packaged pack of 10 or more PSBs. So can the administration please explain what pre-packaged pack means? Is it pre-packaged by the seller to the consumers or by the manufacturer? Please elaborate on this point before we go further. I'd like to know whether there is any problem here. Who would like to take this question? Schedule 2, Section 1. The legal advisor was referring to pre-packaged pack, and they may not necessarily be pre-packaged by the manufacturer. In Schedule 2, 1, 2B, the situation, or 1B, the situation is similar. If 2 or more plastic bags that are sold as a pre-packaged pack at a price of $5 or more per pack, then the levy of 50 cents is not necessary, and we have considered the price of $5 and the pack of 10 bags. I understand this point, but the administration is proposing to make an amendment that is 1B in Schedule 2 will be deleted, only 1C will be left, and that is why I compare 1C with Section 18A to I compare these two provisions. I want to raise this point because the administration just now raised an example of garbage bags, and I'd like to know more about this. When we talk about garbage bags or refuse bags, they're mostly flat top bags that are pre-packaged as a pack of a certain quantity, and I'd like to know what its relationship is with this 1C or Schedule 2 1 bracket C. I'd like to know why the administration has picked the example of a garbage bag. Schedule 2, colleagues, please look at the marked up copy. Is page 24. The title says the plastic shopping bags to which this ordinance doesn't apply. So the administration is proposing to make some deletions, and only 11C will be left. And if this is compared with 18A, which says each prepackaged pack of 10 or more PSBs, we'd like to know the relationship. They're dealing with different types of goods. For garbage bags, if there is if it's a flat top bag, during the first phase it will be excluded, but in the second phase it will be included as well. So apart from garbage bags, we can also think about sealable bags and also other kinds of bags that will be sold as a pre-packaged pack. So these will be relevant. For C, during the first phase, which only covered supermarkets, some goods are already packaged in a plastic bag before it's supplied. For example, a bag of rice, and if there was a handle, and then it will be regarded as a PSB to which this ordinance apply, and 50 cents levy will be necessary. Now, as for other pre-packaged pack, we considered that even if you bring your own bag, there is no way you can save the bag, and it will be excluded in the first phase. And this also applies to the second phase, and that is why in 1C we have not deleted this part. Only that we make this amendment because the retailer no longer applies. We just changed the word seller.
Please continue. Let's look at 18 capital A. The administration's approach is that who prepackage the goods doesn't matter. Whether it's the wholesaler or the retailer, it doesn't matter. You just look at the way it's packaged. Chairman, I don't quite understand some of this. 18A, 2C, each prepackaged bag of 10 or more plastic shopping bags. I thought each bag costs you 50 cents, and now you have to get 10 or more before you have to pay 50 cents. Well, 18A2, well, if the seller comply with A, B, and C, and that is provide plastic bags to the customer directly or indirectly, then the charge has to be collected. In some cases, the bag is not provided one by one. Sometimes the goods, well, it's a bag, or you may have many garbage bags packed as a piece of goods, or sealable bags, because each garbage bag fulfills the definition of plastic shopping bag. So the charge will have to be imposed on each of the garbage bag. That's not the policy intent. If you have a piece of goods in a prepackaged pack of garbage bags, then it has to be subject to a charge of 50 cents. We should adjourn by 4:30, and that's another meeting, AJLS panel meeting. The chair lady is anxious that they should have a quorum. We have started the cross by cross, and we have reached some major provisions. Section 18, Capital 8. Thank you, government officials, and thank you, legal advisor, for your advice. Let's continue after the break. There are 2 slots. The 8th of October or the 22nd of October. For the former, it's 2:30. For the latter, 10:45. The venue is going to be room 2A. On Thursday morning, I have to give lectures, so I have to quit from your university. No. I hope you can work out something to accommodate my timetable. Thank you for your advance warning. We'll work something out. If there's nothing under AOB,